Good afternoon, everybody. My name is Lilla Farkas. I teach at the same institute where Gábor Győző and Ádás Kovács. And I used to be a strategic litigator, a human rights lawyer. I used to work with Gábor, and I've been in the same network as Romaniţa forever. And here we are. They asked me to do something with this 75 minutes and the three stranded speakers who will talk to the other side of the bench, okay? So they will be talking to what lawyers are doing and how lawyers are trying to engage judges and courts in applying EU law. So we have Romaniţa, who used to be in private practice and who used to work for human rights organizations, and she's a consultant for sure. Is she still in private practice as a lawyer? We could say, anyway, when it comes to CJU cases, she's definitely in private practice, and she's been working with OCCHAT, which is the biggest and most active gay rights organization in Romania. And we have Jasper, whose family name I cannot pronounce, and I am so sorry about this. Please help me out once you come on the scene. And he's teaching at the Radboud University, and he's specifically focusing on preliminary referrals to the ECJ. So it's great to have him. And then we have Gábor Győző, who's a lawyer with the Hungarian Helsinki Committee, and he's been on a number of CJU preliminary referrals, and obviously he has a lot of knowledge about the European Court of Human Rights as well. Same goes for Romaniţa, by the way. So these are two Europeanist, internationalist lawyers and two academics who are into international and European law. We will be discussing 5 questions that we have agreed on in advance, and everybody is going to get 5 minutes to answer these questions. So the very first one that I would like to pose, and we will go like Romaniţa, Jasper, and Gábor in answering this. What makes a great preliminary referral in the eyes of a lawyer or an academic? Not a judge, a lawyer or an academic. Maybe we can learn something from this. Romaniţa, please.
Hello, everybody, and thank you for the invitation, Lilla and colleagues. I would have to start by with a caveat, and the caveat is that the cases that I am engaged with, and I will mention, are strategic litigation cases that are human rights cases built by Romanian NGOs or Bulgarian NGOs in their attempt of improving the legislation by in their attempt of bringing in line national legislation with EU standards, which means that for the Romanian judges, these cases were doors for openings for starting the dialogue and creating a bridge by finding strong partners with the Luxembourg court, and in convincing the Romanian judges to send the referrals. Our emphasis was on the importance of this dialogue. And as I will explain, one of these cases, for example, is a case in which the Romanian Constitutional Court decided for the first time to send the referral. The number of the case is 673 per 16, the common Hamilton and Accept case, which relates to recognition of same-sex marriages in other member states. Well, in this case, for example, the Constitutional Court used the referral in order to establish its legitimacy in a very sensitive political context. The referral was sent at the time when a referendum on the definition of family in the Romanian constitution was discussed. So in this way, the dialogue between Luxembourg and the Luxembourg court and the Romanian Constitutional Court enhanced the standing of the Romanian Constitutional Court, which had to rule both on the constitutional referendum and on the particular provision in the Romanian Civil Code, which specifically prohibited the recognition of same-sex marriages legally entered into abroad. So briefly, to answer to your question, Lilla, I think what makes a great case is not only the interest of the parties, the purpose that we have when we start the litigation. For us, it is an obvious purpose, systemic change that comes with our vision, with our values, but it is also this approach of creating a secure space for judges, European and domestic judges, to engage in a dialogue. And in all our cases, we looked at this dialogue not only as a dialogue between Luxembourg and national judges, but also a dialogue between Strasbourg, Luxembourg, and domestic judges. But I think we'll come back to this.
Okay, wonderful. Thank you so much. And now on to something completely different. Jasper, what does an academic think about like a great preliminary referral?
So you put me in I speak on behalf of all academics. No, first of all, thank you for having me here. Perhaps before I answer your question, I can sketch where I come from in terms of, let's say, the basis upon which I make my statements. So I've been doing a research project for the past years on, let's say, the use of the preliminary ruling procedure by national courts in 3 jurisdictions, the Netherlands, Ireland, and the UK. This decision about the UK was made before Brexit, but I've been interviewing judges from all courts, from lower courts to the highest courts, and asked them about their motives to refer, but also what they think of the, let's say, the procedure and the dialogue with the court and the resulting answers. So that has been a project I've been working on, but I've also been, let's say, complementing that with, let's say, research on the Strasbourg court, similar research about why they use Protocol 16 or how they engage with the Strasbourg case law. Very much interested in the field of fundamental rights and the rule of law. So I've also been dealing with European arrest warrants and mutual trust cases. So this is, let's say, a bit the context so that you know where my remarks come from. So let's say the question of, well, what is a good reference? Let's say I'm not answering that now from the perspective of let's say, strategic litigation, but more, let's say, from a legal academic point of view. I think what a judge needs to do in a good reference is, well, of course, satisfying all the requirements in the, let's say, rules of procedure and the recommendations for national courts. So really make a clear reference in which the facts and the national legislative framework are clearly set out, and in which it's also clear what the purpose of the reference is. And this latter might sound obvious, but what I noted is that there are various different ways of referring, or various motives. Well, in strategic litigation cases, a bit what Romaniţa sketched, perhaps in some cases, the answer from the EU law perspective is pretty obvious, but the domestic political context is as such that, well, the referring court needs the backing from Luxembourg or Strasbourg. So they refer in cases in which actually you could say from an EU law perspective, this is clear. There's no reason to refer. but the court refers, let's say, for different motives. And I think courts should make that clear somehow, because if they don't, what you then sometimes get is that Luxembourg does not really understand what the court wants, and is just saying, well, this is so clear, by way of reasoned order, we more or less dismiss the case. So I think it's important that national courts are a bit more open about, let's say, why they refer. And secondly, ideally, they should also, with the idea of engaging in this dialogue, and I know that, well, it's not entirely a dialogue. Most judges actually think it's very much a monologue, because, well, the Court of Justice does not really listen that well. But in order to facilitate a dialogue, courts should also, let's say, ideally include a provisional answer in line with the recommendations, and try to, let's say, give some hints as to the answer they have in mind themselves. So I think, well, national courts should avoid that they merely throw, let's say, their issues over, let's say, the chat and then leave it up to Luxembourg. They should provide, let's say, well-reasoned, solid references that really enable the court to provide the answers they need. And this also means that, well, I use often the term "it takes two to tango." We can be critical of, let's say, the Court of Justice in Luxembourg because they don't answer the questions, or they answer it in a wrong way. But it's often the order for reference of the referring court that is setting the scene. And if the order is deficient and does not engage with all the relevant facts, then that pushes the problem to Luxembourg. So it's important that well, the orders are solid. And well, I can imagine I'm now also, let's say, a deputy judge, and I take some cases. I've not referred a case myself yet, but I realize that it's very difficult to make a good reference, and it also requires, let's say, expertise and some experience with it.
Okay, thank you very much. So basically, Jasper is saying, if you're a referring judge, the best refer is when you're wearing your heart on your sleeve. Okay, so you like put your cards out, let the CJU see why you're actually engaging in judicial dialogue. You're coming on very hard from the very first intervention. We will see whether the judges have something to say about this intervention. Okay, we're coming to Gábor.
Okay, thanks guys for having me. As Lilla has presented me, I work for the Hungarian Helsinki Committee, which is an NGO working in various fields of human rights, including asylum and immigration. And nearly all of our cases are related to that field, which where a primary reference was made. And you may also be aware of the shape of the asylum system and the rights of asylum seekers and refugees in Hungary. You may have heard news about it, and that why it's a first and also a last resort for us to use primary reference to try to to build down all the obstacles that has been constantly being built up before us, and the rights of asylum seekers, and how the asylum system is constantly deteriorated due to the constant changes in legislation. So it is really a very important tool for us to try to make changes in the system, and fortunately we have managed to do in several cases, including the closing down of the transit zones in the Hungary-Serbia border was due to a primary referral. And also just very recently the CJC ruled on how classified data can be used in asylum and also in immigration cases, and those are also all of them are very important for our job, and they are all due to huge efforts in strategic litigation. And my view is that the great referral is when the perspective is as wide as possible, but still relevant for the case, because we are I mean, there is always an urge to see the CJU as a kind of constitutional court, but CJU constantly refuses to act so. So CJU does not want to rule on abstract cases, although we would like to, build down the system as a whole, but it's not possible. So we really have to bring on individual cases and try to reach the general legislation from this individual point of view. And I think it's very important that we don't lose that kind of focus, to start from the individual cases, but go for as wide scope as possible. I think this is what really important is.
Okay, so there are a lot of needs laid out by the panelists. I think, like coming up with the contextual analysis from the CJU's part is a very big ask, and I haven't really seen that many decisions or judgments that have been able to match up to this need. Let's see, what we think about this in the next kind of questions that actually relate to how to persuade the judges to refer, especially on cases of fundamental rights, not tax law, not the typical single market grant, but on fundamental rights cases. Let's start with Jasper, and then Gábor, and then Romaniţa. How to convince the judges?
So on the basis of, so I've been interviewing, I think around 150 judges and also asked them about their stake on, let's say, the role of the parties. And here I saw considerable differences between, let's say, countries, but also within countries between courts. In the Netherlands, let's say most of the references actually stem from the own volition of the judge, especially at the highest court level. So courts are quite willing to refer from their own motion without a request, and they don't actually always check whether when they want to make a reference, whether the parties agree with that. But in other countries, let's say Ireland and the UK, the common law countries, this is an entirely different system whereby parties in general have more, let's say, power. And there I saw that courts are really reluctant to refer if the parties don't agree. Sometimes parties get, let's say, even the pen more or less in their hand, and then they can write the actual reference. So there are, first of all, differences in that respect. But what I noticed in the Netherlands, how to persuade a judge, well, what I heard, first of all, a bit the sentiment that it's sometimes parties quite easily shout, well, it's unclear, please refer. And then courts think, okay, yeah, well, if they just use that as a rather weak weapon, then we don't have to do anything with it. But what they very much like is if the parties can really set out the scene and make clear that there is reason to refer, that there is an acte clair, that there is a doubt about the interpretation by showing, let's say, we have jurisprudence of the Court of Justice pointing in this direction, we have this part of jurisprudence, meaning there is a question that we're confronted with, or EU law or the Court of Justice might, that there might be an inconsistency with the Strasbourg case law or the ECHR. So instead of just shouting, please refer because we want you to refer, the party should, let's say, clearly set out what the problems are in terms of, let's say, the acte clair and the 267 framework. And if they do so in a good way, then, let's say, courts are generally, at least in the Netherlands, quite willing to take it up. So that would be, for now, my intervention. Thank you.
So basically you're saying that the parties really need to do their homework, otherwise it's not going to fly with the judges. Is there anything on the judges' side that needs to be added to this homework? Is there a particular attitude on the judges' side that makes it easier for them to...
Yeah, certainly, especially at least in the Netherlands in the field of migration, you see considerable differences as to, let's say, the willingness of judges. So there are some judges who are quite, let's say, eager to refer. For example, yesterday, you might have seen it, the judgment from the Court of Justice about ex officio review of the non-refoulement obligation. Well, that was referred by a Dutch lower court, and actually a judge who has been behind many of these famous references from the Netherlands that resulted in Grand Chamber judgments. So what I noticed is that, especially in the field of migration law, you see noticeable differences between judges, and some are simply more willing than others. And that also holds true for example, there are differences between the highest courts in the Netherlands, whereby the Supreme Court dealing with tax and civil law and criminal law tends to be, let's say, more loyal to the Article 267 framework and is not, let's say, using Silvit and the Acticlair framework as an easy excuse not to refer. So they're a bit more strict, whereas the highest Dutch Supreme Administrative Court tends to apply Silvit with some reasonable, let's say, they apply it in a less strict way, because their reasoning is if we apply it very rigidly, then that means that we would have to refer on a weekly basis 3 or 4 cases. So that's undoable. So you see that courts, even though, let's say, the legal framework is the same, that courts, let's say the institutions, tend to weigh the aspects differently, but also individual judges. Some are more willing. It also requires you some, let's say, because a reference is quite time consuming in terms of drawing up. And there are also some sort of psychological risks in the sense that, well, as a judge, if you refer a question that has also already been answered, that looks a bit silly, yes. So it is quite a daring move to turn to the court in Luxembourg. So you don't do that easily. So that requires experience, expertise, and some judges are simply more willing to do so. Also, judges with an academic background, they tend to usually be more willing to refer and engage with EU law and the development of EU law than judges who has made a career via, let's say, the law firms or the judicial system. They are more focused on how can I solve the case, whereas academics tend to be a bit more, let's say, okay, let's contribute to the development of EU law.
Okay, thank you so much. I will come back to you with the current alter question, okay? Whether it's the lower court judges or the higher court judges, if we have time, but I'm just warning you in advance. Gábor.
Thanks. Kind of envy Jasper for working in a country that's been, member to the EU for more than much more decades than Hungary does, because I think it has kind of relevance. Like in my experience, and I've been an attorney for 20 years now, and so I had the chance to kind of see how the judge's perspective evolved after the accession to the EU, and I saw that in the beginning, EU law was regarded as some kind of obscure something in the shadows or up in the clouds that should not be touched upon, and I think this mythical nature has become more in the recent years, but it really takes a lot of persuasion, because I feel that there is still a need to highlight how EU law covers specific areas of the law which are at stake in the given legal debate, and I think I cannot stress the importance of strategic litigation enough, because it's very important in our experience that we have to push and push and push and push the same issues again and again and again, and in the end it will probably trigger some response, and this is our experience. Like, for example, with the classified data issues, we've been bombarding the courts for years, and after a while one of the judges, and then we cannot really say how. I have my thoughts about this, which I wouldn't like to. I mean, those can be kind of sensitive issues, but let's not get into that. Why judges are more open to an EU-related issue in Hungary and in other EU member states, but we can see that that strategic litigation really can make an impact, and the one or two open-minded judges can be found after a while, in my opinion.
Shopping for quorums and you finally find the judge that you needed. Is it clear to everybody what Gábor means by strategic litigation? Is it in your vocabulary? Okay, I'm just asking just to make sure that we're not avoiding questions here and answering everything. Thank you so much. Romaniţa.
I would start with fully endorsing Gábor, both in his final finding regarding the importance of educating your judiciary and coming with arguments about the transposition of EU law in the national legislation that are so clear and so convincing that it becomes compelling for the national judge to make the referral. But I'm also endorsing Gábor in his envy of Jasper regarding the experience of judges who had this longer period of socialization with EU law and use it as a part of their toolbox on regular basis. In the Romanian context, I would make a distinction between the judges in the domestic courts, which you have to convince, and luckily there is an increasing number of judges who are doing this type of trainings and courses the way that you're offering with this program. So they are more eager to take our arguments and make the referrals. And then the constitutional judges, which are politicized. And to be fully honest, this big case that Judge Lenaerts, the president of the Luxembourg court, defined as the lightning rod of the EU court in asserting fundamental rights, was actually a case that the Romanian Constitutional Court considered to be a hot potato. So they sent it, they had the referral as a way of finding their way in a very sensitive domestic context. So there are different arguments with the constitutional judges, with the more politicized judges. I think the allies matter. It is important who is sending the amicus curiae and who is participating in the process, in the trial itself. It matters what is happening outside the courtroom, how the media is taking on the topic. And this goes back to strategic litigation as a part of a bigger systemic change of a strategic advocacy plan that you have. With the national court judges, with regular judges, I think what matters is not necessarily the amicus, though that is also something that might help. What matters is the clarity of the questions, and actually, in a way, helping them to do their homework, having the referral, the question phrased with the clarity that makes it easy for them to take it forward. And that's also an advantage for the lawyers building such cases, because from our experience, like when preparing the cases, we looked at what other referrals went through from the courts, from the particular panels where our cases were. So we are vetting the judges, both checking the preference of the judges in phrasing the questions. If you come up with a convoluted and verbose proposal of a referral, is not going to fly. I mean, the national judge doesn't want to make a fool of himself or herself. So it will probably rephrase, and then there is a risk of losing the important details of the case. So it is essential to look at the judge as a partner and make this, for me, this is a partnership between the national judge and the Luxembourg judge, but also with the parties, with the national lawyers being engaged in this partnership and building this bridge together.
Okay, thank you very much. So can I open the floor for questions, just for 5 minutes, okay? Because first, I don't want anybody to fall asleep. I do apologize. Like I like an animated discussion. Second, because it is the judges that we are talking about, and the judges haven't gotten the microphone yet, I think it's fair treatment that I give you the word for 5 minutes, okay? So let's see who would like to react or somehow respond to these kind of characterizations of your work and your status and your persona.
I'm Veronica Gaviș-Odinga, a Romanian judge.
Can you hear her? Jasper Krommendijk, okay, cool.
I'm a Romanian judge, and before I was a judge, I was a lawyer for 10 years. And that's why I became a judge, in order to apply. I fought the system, you know. I cannot say I beat the system, but I was in the system. I infiltrated in the system, you know. So I think one of the solutions to the informations to go to the judges, maybe by universities, by schools, academic, I don't know, preparation, and teachers, judges usually take part in different courses. There's or the National, I don't know, Institute of Magistratures who form judges, or by Judges Association, in order to respond to your question. How can you reach your problem to be heard, really heard, and applied, and be applied, and to be clearly understood? You know, it's a kind of solution to speak loud. And the press, you have to bring the press to you, and to, I don't know, by power of example, of the raising what you mean, congratulations for all your activity from the basis you started. I googled a little Hungarian Helsinki Committee, and you raised very, very much awareness of the importance of your work, and it's great that you grew, and you need to grow more. So you can gather, I don't know, from universities. There are students' associations. There are people who want to make good, but they don't know how to make good in the world, you know? So good luck.
Okay, thank you very much. Anybody else who would like to reflect on what has been said so far? No? Don't tell me I haven't asked you. Okay? Cool. All right. So the next two questions are somewhat related to each other. So I'm going to read them out together, okay? And you will see which one you want to lean on more. So we've been talking about the use of the comparative law method in referrals, because that's something that the European Court of Human Rights is very much engaged with. And it seems to me that the CJU in fundamental rights cases is also flirting with the idea of using the comparative law method, which lands us to the other question, which is there a competition, or is there some kind of rivalry between international courts, such as the European Court of Human Rights and the CJU? And if so, can you use it to your advantage? All right, with only this little package of questions, I give the floor to Gábor.
Okay, with me having the least academic knowledge about these issues, but
I'll try to do my best. So, yeah, in our cases, I can rely on the practice of our organization. We often launch cases parallel with each other. So we try to litigate the same issue at the CJU and at ECHR as well. And I think both has advantages and disadvantages at the same time. And this is why I think it's very difficult to talk about rivalry as far as from the petitioner's side is concerned, because the methods are completely different. I mean, with the preliminary ruling procedure, you have to convince a judge. With the ECHR, you don't have to convince a judge, you can apply yourself, which is a huge advantage. But at the same time, my impression is that the making a difference is much more difficult with the Strasbourg court as with the Luxembourg court, because the procedure is much more formal. I mean, there are no member states intervening, or third-party intervention is still not a very regular thing that is done. So the inputs are much more much more limited. Thank you. As compared to how preliminary procedure is conducted. And the Strasbourg procedure is very long. A preliminary procedure is completed within 1.5 years at the most. If it's a PPU procedure, it can be just a couple of months, which is really a huge advantage. So and my impression is that while both rely on individual cases, at least in Hungary, if there is a victory in a Strasbourg case, it still be considered as an individual case, which will have a much less impact on either on the legislation or on the judicial, for example. And I think in Hungary the judges are still kind of reluctant to rely on ECHR, although it's an international convention, and EU law, because it's standing within the Hungarian and all European legal system, that it was reinforced by even the Constitutional Court that it should be respected. Although nowadays we see how this respect goes in some cases, but in general there is a constitutionally founded respect for EU law, and this is why it usually is much more effective to rely on EU law than on the jurisprudence of ECHR, however sad that may be.
So EU law has a bigger pulling effect, but you guys actually, you made the two courts compete in relation to the transit zone.
For example,
you can tell us how you did that, how you pulled that off?
Actually, we just,
and you needed the CJU to actually raise
and actually,
because Strasbourg was...
Yeah, and actually it was CJU who dismantled the transit zone system in the end, because we needed to bring asylum cases in front of a Hungarian judge and try to explain that apart from the in-merit part of an asylum application, the detention conditions should raise questions, EU relevance issues, and which is totally different from the Strasbourg application, which didn't really end so well in the end, because that did not result in, although that there was a grand chamber decision in the transit zone cases. You may have heard about the Elias and Ahmed case. And still, it did not have the same impact as a later CJU judgment had. So that clearly makes, clearly shows who won in that competition, at least in the transit zone cases. And I think it lies in the very nature of a preliminary ruling procedure.
It lies in the nature of EU law being transnational and the European Convention on Human Rights giving too much leeway to the states. Thank you so much, Gábor. Romaniţa.
I don't see the two courts as competing. I see them as being on the same track, at least in terms of recognizing the fundamental rights. The biggest challenge comes from the limitations of EU law. As lawyers, we have to find the ways in which we can frame the issues to fit in EU law. It's a Procrustean bed, but once you manage to raise an argument that fits under the EU law, I see more advantages with the Luxembourg court, not only the faster track, but also the advantage of the Commission coming in and being often a valuable ally. Also, some of the member states are contributing to the dialogue, and this brings that comparative element, comparative law element that you were asking about. But otherwise, in all the cases that we build, which are human rights cases, so I've been clear about this from the very beginning. In all these cases, the Luxembourg court used the arguments from the case law, relevant case law of the Strasbourg court. So as lawyers, we made sure to include in our argumentation the positions of the Strasbourg court, and we did this before the national court, but also in Luxembourg, and with the most recent decision in C4 per 2023, which came 2 weeks ago. Actually, the judges of the Court of Justice of the European Union are using the statements, the findings of the Strasbourg court in a Romanian case to actually spell out the responsibility of the Romanian authorities in recognizing LGR documentation issued by another member state. So that is showing that the Luxembourg court just not copy-pasted, but took over the message, the initial conclusion of the Strasbourg court, and built on that. And it was the same with prior cases, like in the Coman case, which was a same-sex marriage. The Luxembourg court referred to Tadeusz McCall and to Oliari, so the jurisprudence of the Strasbourg court. There is a dialogue. Now, I don't know what will happen on the other side with the Coman case after having this huge success in Luxembourg and with the Constitutional Court. We ended up now in Strasbourg on the same case. So we'll see if the Strasbourg judges are willing to carry on with the dialogue and keep on building around the arguments used by the Luxembourg judges, but I see it not as a competition, but as a puzzle in which each piece is coming together and beautifully building towards a shared platform of protecting fundamental freedoms. And then because it's a common interest and it's a common way, we can see the pieces of the puzzle coming together.
Okay, thank you so much. LGR, legal
gender recognition.
So this was the case that Romaniţa was talking about. Okay, so I tell you why I asked you this question, because there's the charter, I think Article 52, which actually foresees some kind of rivalry, because it says sometimes the standards of the European Convention on Human Rights and the court itself are not good enough under EU law. So this is why I'm asking you guys, like obviously with the LGBT stuff, the Strasbourg court has actually reached the limit. Okay, so there's no further space to go. There's room for other things. But with the rights of migrants, the Strasbourg court hasn't reached its limits. And the CJU has gone further. So obviously there is a bit of a competition depending on the type of cases and the type of issues that you're dealing with. So Jasper, let me just undercut you and put you on the spot. What do you say about this? What does your research say about this? This little inbuilt rivalry.
Yeah, I think I must side here with Romaniţa that at least currently, it's very difficult to speak of competition or rivalry, but there is some piece of truth in what you were saying. Indeed, 52, paragraph 3, etc. So this was different, I think, 10 years ago, around the time of Opinion 213, in which the Court of Justice prevented accession of the EU to the ECHR. And 2 weeks before the opinion was rendered in December 2014, I also did interviews with judges at the Court of Justice and asked them how and what their reasons are to engage with, let's say, the Strasbourg case law. And remember, this was 5 years after the entry into force of the Charter. So the Charter was the new kid on the block. And it was interesting that judges were quite, let's say, they also used this competition rivalry language a bit, if I remember it well, in the sense of that, well, we now have our own charter. We need to develop our own charter. So we're not relying that much on Strasbourg. We have to come up with our own autonomous interpretation. EU law is different. We have a different legal order, which is not always understood well enough in Strasbourg. So we determine ourselves the standards. So this was 10 years ago, but I think since then, the context has changed fundamentally, not at least because of the rule of law backsliding in various countries, including possibly my own. So we see that EU values and fundamental rights become increasingly under pressure. We now have a new president in it, or now already for some years in the Court of Justice, who thinks differently than the previous president. So instead of this more, let's say, antagonistic relation, we now see that Luxembourg and Strasbourg are very much trying to cooperate in the light of the increased pressures on, European values and fundamental rights in general. So they increasingly rely on each other in their work. So that holds true for the Court of Justice, but also in Strasbourg. Well, it's a pity that I wrote it in Dutch, but I just checked it. Last year, I wrote how, the European Court of Human Rights in Strasbourg is increasingly acting as a guardian of EU laws. So there are various cases in which, they really enforce compliance with EU law standards and Court of Justice judgments in their judgment. And they argue that the fact that national courts are not, complying with EU law or Court of Justice judgment is also a violation of the ECHR. So that is, I think, quite interesting. But that doesn't mean, and I think that is the point you made, Lilla, that there are differences between the courts. And in the area of migration law, I think in some respects, the Court of Justice is seen as the better protector, also by national court judges. In some areas, think of, I guess you discussed that yesterday, the criminal law cooperation, European arrest warrants. Well, there's criticism on the Court of Justice that it's too restrictive in terms of its two-step test, and that perhaps Strasbourg offers more protection. So indeed, there are these differences, but I think competition and rivalry is, yeah, I think currently, I don't think we should use that terminology to depict the situation. And then, well, I think indeed for litigants, also in the view of strategic litigation, it's actually quite useful. First, perhaps you try the Court of Justice in the pending domestic proceedings. Well, you try to persuade and push the judge to refer. If that doesn't work, or if that works, well, you go all the way up to the highest court, and then you still have the possibility to turn to Strasbourg. So these procedures could go hand in hand, and I think, well, litigators could use them complementarily, and they should indeed, as Romaniţa sketched, indeed also use in their procedures before the Court of Justice or on the basis of EU law. They can also rely on ECHR law, and the other way around. So I think these systems reinforce each other.
I mean, in theory, you could actually try a case in which you have a preliminary referral during the trial stage. If you do not get the judgment you wanted, you could go to the Strasbourg court, which I think is something that you should do on racial discrimination, because that is a field in which the CJU is lagging behind the Strasbourg court. So I'm just saying, because, you know, I'm a race girl, I used to litigate racial discrimination, and I begged Hungarian judges to refer. Nobody wanted to, and it's not just the Hungarian judges. So what I'm saying, if I give you different areas of fundamental rights, you give me different answers as to the activism of national judges. Okay, so now on to the very last question, which is basically trying to create a bridge between strategic litigation by NGOs and its reception by domestic judges and by CJU judges. What say you? What is the big picture, Romaniţa?
That's an unfair question.
That can be answered in 5 minutes or less. You know.
I don't see the big picture yet. What I see instead is a Europe in which the rule of law and the fundamental freedoms as we know them, as we embraced them and we studied them when we went to the law school, and some of us still believe in, come under threat. And because of this, I see the judges in the front line having this position of last defenders while being under attack themselves as well. Okay, I can speak about the Romanian judiciary, but I'm afraid the situation is not much different in the region. So in this regard, having knowing that we still belong to shared values helps in terms of group therapy, helps in sticking with the cause and knowing that it's not all lost. But it also helps in knowing that we are not alone and we have allies, partners in the European courts and in other member states. So for me, this dialogue between the academia, the activists, the researchers, the judges at the different levels, it's very important. And I see this as the only way of keeping the European dream the way we want it to be, and not allowing ourselves to be hijacked by populism and totalitarianism. Is that picture big enough?
I think so. This is a difficult, like strong message, hard to follow, but I will give it to the two boys to follow.
Jasper.
So what's your take, Jasper? What's your take on
sorry, sometimes
of judges? You know, like how do they complement each other's roles? Who's more important? Can we do anything without the judges under EU law if we want to strategically litigate?
I indeed echo a bit what Romaniţa was stressing. Also from, let's say, the perspective in my country, well, you know that we now have a populist, radical or extreme right party in our government. And the rule of law is also increasingly under pressure. I was part of a committee of lawyers. We were commissioned to draw up a report by the Bar Association in the Netherlands, let's say, reviewing governmental program in terms of rule of law and fundamental rights. And we actually, well, not surprisingly perhaps for you, on various fronts concluded that there are serious problems in terms of the rule of law. And this, let's say, parties know it, and I imagine that in your countries it's perhaps not very different. They know that, well, they are violating EU law or fundamental rights law with their measures, and they don't care. They actually, it's nowadays seen as something positive. And the more damaging thing is that this is done on purpose, and this with the view of also delegitimizing courts who are indeed put in the position of correcting and acting in favor of our rights, delegitimizing the EU, because the EU law is preventing us from reaching the decision we want. So I think this is really troublesome. So yes, it's very nice that we have a strong EU law system with a strong court. And well, talking for my country, we have quite a solid judiciary who also engages quite noticeably with ECHR and EU law. That's all wonderful. But let's say the longer term prospect is that, well, this puts the courts and the judicial system in quite an odd place in which they have to strike down, annul measures that, well, most lawyers would have said in the beginning that they couldn't be implemented because of the violations with the law. So that is my concern. So in that sense, yeah, we need indeed, I think, increasingly activists, academics, lawyers, judges cooperating in order to, let's say, maintain the democratic rule of law system that has been built over decades.
Okay, thank you very much. Gábor?
Mostly everything has been already said by Romaniţa and Jasper, so I have very little to add, actually, because I agree with all that's been said. I really do think that we all have to understand that every one of us who works in the field of law has to be committed to fundamental rights. I mean, fundamental rights, it has to be understood that fundamental rights are not just the plating of, I don't know, liberal NGOs. And these are really, fundamental really do matter. And I agree with Romaniţa that these are really trying times. And we have trying times ahead. And we really do have to kind of stick together because we, or possibly the judges, may be the final bastion standing in the battle. Sorry to be so dramatic, but really this is what I think. And we really need dialogue, and we really have to really understand each other. But it refers also to us as legal practitioners. We really do have to understand how judges think, how judges feel, how judges are maybe bound by certain things which we might not understand because we are not working in the judicial field. So it would be very good to have areas and room for communication, which we don't. I mean, we would really need sessions like this, where judges and attorneys and maybe prosecutors and academics come together, share ideas, and really try to be engaged in a communication that really can enhance the issue of fundamental rights.
Okay, thank you very much. So I think we can conclude that we cannot do strategic litigation without the judges. And the more involved the judges are, the better the strategic litigation will be. So there is definitely a strong need for collaboration, first between the judge and the attorney, and then between the judges at different levels in order to leverage EU fundamental rights. All right, if there are no other questions, are there other questions from the floor? If no, then thank you very much for the panelists. You were great. And I hand over to Anne.